All right, everyone, welcome back. Today, we're tackling a subject that's, well, essential for any leader, but not always the most thrilling read: U.S. employment law. We're going deep, folks, hoping to equip you with what you actually need to know to make smart choices, not just survive, but thrive in this landscape.
Exactly. Think of this deep dive as your guide to navigating that legal maze, avoiding those pitfalls, and really making sure your workplace is both fair and legally sound.
Music to my ears. And judging by the mountain of questions from you listeners, this is a hot topic. So let's start with the basics, the very foundation. The U.S. legal system itself. I mean, it's a bit of a beast, isn't it, with layers upon layers of rules.
It can feel that way. You've got federal law, right? That's nationwide. Then each state has its own laws. Sometimes even cities or counties get in on the act. And then on top of all that, you've got court decisions, precedents set by judges that impact how those laws actually play out.
Yeah, talk about a recipe for confusion. It's like trying to follow instructions written on sticky notes, some in crayon, some maybe in a different language. Where do you even begin to make sense of it all?
Well, the good news is there's one big boss in this system, the one that trumps all the others, the Constitution.
Okay, so that's our North Star. The Constitution sets the bar, and everything else has to fall in line.
Exactly. State laws can be weaker than federal law, but never stronger when it comes to employee rights. So, if the feds say you've got a certain right as a worker, no state can take that away from you.
Yeah.
Makes sense, right? Creates a basic level of protection across the board.
Makes total sense.
Right.
Knowing those federal laws, that's got to be our starting point then.
Absolutely. It's the foundation. But look, before we get too deep in the weeds, I think it's important to remember not every disagreement has to end in a courtroom showdown.
Oh, absolutely. In fact, I'd wager most employers would rather avoid a lawsuit like the plague, right?
100%. Think about it. Legal battles, they're time consuming, they're emotionally draining, and the costs. Let's just say they can be astronomical.
Yeah, I remember reading about a gender discrimination case. I think it was against Goldman Sachs a few years back. Ended up costing them a whopping $215 million. That's a hefty price tag.
Exactly. That's enough to make any company, big or small, think twice about letting things escalate. That's why having a solid internal system for complaints, for resolving disputes, it's not just some nice to have, it's practically an insurance policy.
So it's all about prevention and early intervention. Nip those problems in the bud before they blossom into full-blown lawsuits.
Precisely. Because once you're in court, well, things can get very unpredictable very fast. And that's a whole other can of worms we'll save for another time. But speaking of tricky situations, let's talk unfair discrimination.
All right, discrimination. Now, this is where things get really complex, wouldn't you say? Because it's not always about someone intentionally being biased, right?
You hit the nail on the head. You see, a lot of times it comes down to this thing called adverse impact. And this is where I see a lot of well-meaning employers get tripped up.
Adverse impact. All right, break that down for us. What does that actually mean in practice?
So imagine a company, right? They've got this rule in place, and on the surface, it seems totally neutral. Everyone's held to the same standard. But then in reality, that rule ends up disproportionately impacting certain groups, putting them at a disadvantage.
Okay, I'm starting to see how this gets complicated. Got any examples? Something to help us wrap our heads around it?
Sure, think about a company that requires all their employees to be at least 5'8" tall.
5'8"
Mm.
for everyone.
Yeah. Now they might say, hey, it's about safety, or everyone needs to be able to reach the top shelf. Seems fair at first glance, but realistically, you're going to have far fewer women who can meet that requirement. And likely people from certain ethnicities as well. Even if that wasn't the intention, the impact is clear.
Right. It disadvantages certain groups, even if it's unintentional. So even if a company doesn't mean to discriminate, if their policies end up having that effect, it's still a problem.
Exactly. And that, my friend, is adverse impact in a nutshell. Same standards, very different consequences.
Okay, so we've got the Constitution setting the stage. We've got the importance of early resolution to avoid those courtroom dramas.
Yeah.
And now we're starting to see how even unintentional bias can land a company in some seriously hot water. Okay, we've got our toolkit of legal knowledge. We're ready to see how it all plays out in the real world. Let's talk case law. These real-life scenarios can be incredibly eye-opening, can't they?
They absolutely can. It's like having a front row seat to how these laws are actually interpreted and applied. And they provide some invaluable lessons along the way.
So it's not just about knowing the rules. It's about understanding how they've been used in the past to make decisions, kind of like setting precedents, right?
Precisely. And a great example is the landmark case of Griggs v. Duke Power Company back in 1971. This one really changed the game.
Okay, I'm all ears. Tell me more about Griggs v. Duke Power.
So Duke Power had these requirements for hiring and promotions, a high school diploma, and passing scores on intelligence tests. Seems pretty standard, right?
Yeah, those were, and sometimes still are, fairly common requirements.
Right. But here's the catch. Duke Power couldn't actually prove that those requirements were related to job performance. And not surprisingly, these requirements disproportionately screened out African American applicants.
So even if the rules seem neutral on their face, they were creating a barrier for certain groups. What did the court say about that?
The Supreme Court sided with Griggs, saying that any hiring standard has to be directly related to the job. You can't just have requirements that sound good on paper. You have to prove they're essential for success in that role.
That makes a lot of sense. But it also puts a lot of responsibility on the employer to prove that their practices aren't discriminatory, even if it's unintentional.
Exactly. Griggs v. Duke Power was a landmark case for establishing the concept of adverse impact, meaning even if you don't intend to discriminate, if your practices lead to unequal outcomes, you can be held liable.
So it's not enough to just mean well. You have to make sure your practices are actually fair and equitable.
Yeah.
What other areas have the courts weighed in on?
Well, another area that often raises questions is the use of someone's personal history, like criminal records, in hiring decisions.
That's a tricky one. How do you balance safety concerns with giving someone a second chance?
It's a delicate balance for sure, but generally the courts have said that using arrest records alone is a no-go. Remember, innocent until proven guilty, right?
Right, that makes sense. But what if someone was actually convicted of a crime? Does that change things?
It can. The courts might say it's okay to consider a conviction, but only if it's directly related to the job. For instance, if you're hiring a cashier and the applicant has a conviction for embezzlement, that's relevant. But if someone had a DUI from years ago and they're applying to be a software engineer, that shouldn't be held against them.
I see what you mean. The relevance to the job makes a big difference.
It really does. And even if a past conviction is relevant, you still have to consider the circumstances. How long ago was it? Have they been a repeat offender? Have they taken steps to rehabilitate themselves? It's about being fair and assessing the individual, not just relying on a past mistake.
So much nuance to consider. It's really about looking at the whole picture, isn't it?
Exactly. Speaking of looking at the whole picture, let's talk about sexual harassment cases. What have we learned from those landmark rulings?
Okay, that's a big one. I know the courts have made it clear that hostile work environment is just as illegal as the more overt quid pro quo type of harassment.
That's right. And just to clarify for our listeners, quid pro quo is when someone in a position of power directly ties employment benefits, like a promotion or a raise, to sexual favors. It's the classic sleep with me or you're fired scenario, which thankfully is becoming less common.
Right, but unfortunately, hostile work environment harassment is still pervasive. So we're talking about creating a workplace where people feel unsafe or demeaned because of their sex, even if it's not directly tied to a job benefit.
Exactly. The landmark case here is Meritor Savings Bank v. Vinson. It established that even if the behavior doesn't directly impact someone's job performance, it can still create a hostile environment that's illegal.
So you're saying even if there are no direct threats or promises tied to work, a toxic environment itself is still a problem.
Absolutely. And here's the kicker. Later rulings, like Burlington Industries v. Ellerth and Farragher v. City of Boca Raton, made it clear that employers are always potentially liable for a supervisor's sexual harassment, even if they didn't know it was happening.
Wow, that really raises the stakes.
It does. Those rulings highlighted the crucial need for clear policies, comprehensive training, and a system for handling complaints effectively. They emphasized that ignorance is not a defense when it comes to sexual harassment. Employers have to be proactive in preventing it.
It's about creating a culture of respect, not just checking boxes on a compliance checklist.
Exactly. Okay, one more case to discuss before we wrap things up. Age discrimination. This one hits close to home for many people, and despite being illegal for over 50 years, it's still a persistent issue in the workplace.
It really is. We've heard from a lot of listeners struggling with this. What's the legal take on age discrimination?
Well, the Age Discrimination in Employment Act, or ADEA, protects workers over 40 from being discriminated against based on their age. But here's the interesting thing. Juries tend to be very sympathetic to older workers in these cases.
So if an older worker is let go and a younger person is hired to fill their position, that could raise some eyebrows, couldn't it?
It certainly could. It doesn't automatically mean there was discrimination, but it does put the burden on the employer to prove that the decision was based on something other than age, like performance, qualifications, or a legitimate business restructuring.
So once again, documentation is crucial.
Absolutely. From interview questions to performance reviews, make sure you have a clear, objective, and job-related reason for every employment decision. Solid documentation is your best defense against any potential discrimination claim.
It sounds like a recurring theme in employment law.
It really is. Documentation, clear policies, and a proactive approach to creating a fair and equitable workplace are essential. And remember, even if your state laws seem lenient, federal law or a future lawsuit might have a different perspective.
Solid advice. Act ethically and create a workplace where everyone feels valued and respected. It's not just good for avoiding legal trouble, it's good for business.
Couldn't have said it better myself. It's got to feel good going into these situations, knowing you've got the knowledge to back up your decisions.
Absolutely. It's like having a roadmap instead of just driving around lost, hoping for the best.
Exactly. And speaking of maps, getting a handle on these key pieces of legislation, it's like having a toolkit for navigating this complex legal landscape.
Okay, so let's dive into that toolkit. What are the major acts we need to be familiar with? Give us the rundown.
We'll definitely cover those big names: Civil Rights Act, ABA, the Equal Pay Act, all that good stuff. But more than just memorizing a list, what's crucial is grasping the principles behind these laws.
Okay, so it's about understanding the big picture, not just the fine print. Kind of like, I don't need to be a mechanic to know that driving with bald tires is a bad idea.
That's a perfect analogy. You just need to understand those basic principles of road safety. Same thing here. Now, one of those bald tire level principles comes from the Equal Pay Act. Seems straightforward, right? Men and women, equal work, equal pay.
Sounds pretty clear-cut to me.
Right. But then we get into the comparable worth debate, and things get a lot more interesting.
Wait, comparable worth. I'm not sure I've heard that one before. What's that all about?
So it gets at how we value work, which gets tricky fast. Let's say you've got a job traditionally done by women, like nursing. Then you've got construction, often male-dominated. If both contribute equally to the employer's success, should the pay be the same, even if the skills are different?
That's a tough one. Where do you begin to draw the line there?
Exactly. And the Equal Pay Act itself, it doesn't have an easy answer. It focuses mainly on equal pay for equal work, not necessarily comparable. But it raises these big questions about fairness, about how we measure the value of different types of work. It's something to think about.
It definitely is. Food for thought.
Yeah.
Okay, let's shift gears a bit. What about the ADA, the Americans with Disabilities Act? I know that's all about making sure everyone has a fair shot to contribute, regardless of any disabilities they might have.
Absolutely. And it's about so much more than just ramps and wheelchair access. The ADA, it's about removing barriers for qualified individuals, making those reasonable accommodations so they can really thrive.
So not just physical adjustments, but also adapting the work itself.
Exactly. And this is where it gets really innovative. There's this fascinating example with Walgreens. They redesigned certain jobs to be more accessible for folks with cognitive disabilities. They replaced keyboards with touch screens, big images and icons instead of just text.
Wow, that's incredible. A great example of how accommodations can benefit both the employee and the employer.
Precisely. It's about inclusion, not just checking a box. And often you find it leads to better efficiency and productivity too.
Makes sense. Okay, one more area I want to touch on, those English-only rules. That seems pretty straightforward on the surface, but something tells me it's not quite so simple.
You'd be right about that. Those blanket rules, where everyone's forced to speak English all the time, even on breaks, those are generally a no-go. Courts have ruled those are often discriminatory.
Okay, so what about those situations where it really is essential for the job? Like, say, on a construction site, or maybe in a factory setting where safety is paramount.
Now you're talking. If employees need to be able to communicate quickly and clearly in English to prevent accidents, that's considered a valid business necessity. There was actually a case in California, construction company, they implemented an English-only policy specifically for workers using radios.
So in that specific context, it was deemed acceptable.
Exactly. The court upheld it. It was directly tied to those safety concerns. But, and this is important, a company couldn't just say, well, we want everyone speaking English because we have a lot of English-speaking customers.
Right, so customer preference wouldn't cut it?
Not even close.
No.
It has to be a legitimate business necessity, directly related to job performance or safety, and even then, It's got to be narrowly tailored to the specific situation.
It's all about finding that balance, isn't it?
Yeah.
Between the needs of the business and the rights of the employees.
You got it. And look, we've covered a lot of ground here today, from the Constitution to those landmark cases, those tricky English-only rules, and everything in between.
My head's spinning, but in a good way. It's been eye-opening, to say the least.
It's been a pleasure diving into this with you.
And to our listeners, if you're feeling overwhelmed, remember, knowledge is power. The more you understand about these laws, the better equipped you'll be to create a workplace that's both fair and legally sound. And who knows, maybe even enjoyable for everyone involved.
Here.
That's all the time we have for today. Thanks for joining us on this deep dive. We'll see you next time.